So guys, Nnamdi Kanu has just made a U-turn and Nnamdi Kanu has headed back to the Supreme Court to go and challenge the 2023 judgment that was ruled out against him. Welcome to this YouTube channel. In case you're new to this YouTube channel, kindly hit the subscribe bell below because in this channel, I bring you everything that's shown and everything you need to know regarding Nnamdi Kanu. So ever since Nnamdi Kanu's letter was sent to Donald Trump, Kanu has been following it up with decisive actions in the courts. And despite being in DSS detention, Nnamdi Kanu proves to have had the upper hand in the case against Omotosho because he keeps on bringing and making moves and making U-turns that will facilitate his freedom and bringing to notice what is currently happening to Donald Trump. This is nothing but a positive sign which indicates Nnamdi Kanu's speedy release from detention. In today's session, there is a video clip I'll be playing here for you guys to watch. After watching this video clip, we are going to be heading to every details of what Nnamdi Kanu has just filed because Nnamdi Kanu has filed a fresh motion challenging the Supreme Court why his judgment in the appeal court was being overturned, why the Supreme Court worked on a law that has already been given and worked on a judgment that has already been given. Because in 2022, the appeal court said no court has the jurisdiction to try Nnamdi Kanu. No court has the right to try him on a basis of a law that the judgment has been passed. And that is why Nnamdi Kanu has just headed to the Supreme Court and said, look, I am challenging you guys. Because the Supreme Court came out in 2023 and overturned the appeal court judgment of 2022 that vindicated Nnamdi Kanu, that said that Nnamdi Kanu was innocent. The Supreme Court came in 2023 and said that Nnamdi Kanu has a case to answer when the appeal court in 2022 had already given a judgment. And this is Nnamdi Kanu coming out now and saying, look, Omotosho, you can't work under a repealed law. You can't charge me under a repealed law. You can't charge me in a case that a judgment has already been passed. Well, without wasting much of time, watch this video clip. And after watching this video clip, we are going to be heading straight to what Nnamdi Kanu has just filed against the Supreme Court.
Hello, my people. What is the work of UN? Could you still remember? On 20th July 2022, the UN writes 16-page report asking Nigerian government to release and compensate Mazi Nnamdi Kanu for his unlawful arrest. Do you remember that? They also recommended that government officers who are responsible for his torture are investigated and punished. Where is all those officers until today? Where are them? However, the working group also asked Nigerian government to report back to them after 6 months of the letter, and that they will make sure Nigerian government comply with what they write on their recommendation. Where is all those letters? Now, my question is, what have been UN able to do since 2022 till now? Does that mean the 6 months never reached? Or are they corrupt? They are the bulldog without teeth. What is all this? All the whole world is watching. What is your answer? Think about it. All here, Biafra.
Breaking. Nnamdi Kanu heads back to Supreme Court to challenge 2023 erroneous ruling. And I read in details. The detained leader of the indigenous people of Biafra, IPOB, Nnamdi Kanu, has returned to the Supreme Court of Nigeria, seeking to challenge the per incuriam judgments that shook the foundation of justice and destroyed the rule of law. In a statement issued on Monday by his legal team, and signed by Barrister Njoku Jude Njoku and titled A Judgment Day That Destroyed Justice. Kanu's lawyers stated that the Supreme Court's ruling of 15 December 2023, which overturned the Court of Appeal's decision discharging Kanu, was not merely an error, but a conscious judicial maneuver designed to keep him in perpetual captivity. According to the statements, the five-member panel, led by Justice Garba Lawal, with Justices Emmanuel Ajim, Kudirat Kekere Ekun, Tijani Abubakar, and Ibrahim Musa Saulawa, concurring, in brackets, knowingly relied on a repealed law to remand Kanu for trial. At the center of the controversy is the Terrorism Prevention Amendment Act 2013, which was repealed and replaced by Terrorism Prevention and Prohibition Act 2022 on 12 May 2022, more than a year before the Apex Court judgments. The Supreme Court knew the law had died, acknowledged that a repealed statute cannot sustain a criminal charge, yet proceeded to resurrect a dead law to send Kanu back to Federal High Court, Njoku alleged. Now in 2022, the appeal courts struck out a judgment saying Nnamdi Kanu is innocent, saying no court has a jurisdiction to try Nnamdi Kanu, only for the Supreme Court to rise up in 2023 and quash the judgment of the appeal courts, saying that Nnamdi Kanu has a case to answer. And this is what Nnamdi Kanu is now challenging and saying, look, I can't be tried under a repealed law. I can't be tried under a case that a judgment has been passed. And this is illegal under the 1999 Constitution. Clearly showing you that Nnamdi Kanu is on his rights to tell Omotosho that he has no case to answer. Let's continue. He described the ruling as not an accident, nor an intellectual slip, but a deliberate judicial ambush that misrepresented a dead law as alive. The statements argue that because the law under which Kanu was charged no longer existed, the Apex Court decision was a jurisdictional nullity. In quotes, a repealed law is a legal corpse. It cannot be revived, acted upon, or used to create criminal liability. Once the enabling statute is abolished, the proceedings built upon it collapse, Njoku stated. He added that by applying two contradictory legal positions in the same ruling, first admitting that a repealed law cannot sustain a charge, and then remitting Kanu for trial under the same law, the courts lost jurisdiction. No doctrine of finality can shield a nullity where a judgment is rooted in illegality. The Supreme Court has inherent power and duty to purge its own record, he wrote. The legal team further accused the Supreme Court of breaching Section 122 of the Evidence Act 2011, which obligates courts to take judicial notice of all repealed or newly enacted laws. By pretending that the repealed 2013 Act was still in force, the courts acted per incuriam, in ignorance of binding statutory duty, Njoku contended. He insisted that a per incuriam judgment is not protected by the doctrine of finality, arguing that the Apex Court has in the past set aside its own decision made in similar circumstances. Beyond the legal technicalities, Njoku said the 2023 judgments effectively crushed Kanu's constitutional protection against double jeopardy under Section 36 of 9 of the 1999 Constitution, which bars a person from being tried again after discharge or acquittal. an acquittal on Nnamdi Kanu's case was given in 2022. So therefore, the Supreme Court had no right in 2023 to bring back Nnamdi Kanu's case and bring it up to life. And this is the law telling us that, look, you can't raise a case after a judgment has been given by a court of law. And the appeal court is a competent court of law, which shows you what Njoku, which is Nnamdi Kanu's lawyer, is trying to state here in this very motion that was signed and sent by Kanu. Well, let's continue. The Court of Appeal had discharged Kanu, which triggered this constitutional shield. Yet, the Supreme Court stripped him of these rights and sent him back to face the same charges the statements read. Njoku described the ruling as judicial punishment, asserting that it sent a dangerous message to the Nigerian states. In quotes, "Bring him back and try him again. We have removed the shield. This is not law. It is vindictive jurisprudence." Kanu's lawyers argue that their new motion before the Supreme Court is not only about his personal liberty, but about safeguarding the rule of law in Nigeria. If this per incuriam judgment is allowed to stand, death laws can be revived to prosecute citizens. Double jeopardy will lose its meaning, and courts will become co-agents of government reprisal, Njoku warned. Finally, he maintained that correcting the alleged judicial blunder is essential, not just for Kanu, but for every Nigerian who depends on the courts for justice. Well, you can imagine that it is because of the Supreme Court's mistake and erroneous ruling, according to Njoku, that has kept Nnamdi Kanu where he is today. Because if the Supreme Court had obeyed the ruling of the appeal courts, Nnamdi Kanu should have been an innocent man walking freely on the streets of every way he wants to find himself in. And now Nnamdi Kanu has risen up and said, look, I won't accept what the Supreme Court did in 2023, that I must challenge their judgments, that I must challenge their erroneous ruling. And yes, Nnamdi Kanu is on his rights, because on that very 2022, or in that very 2022, the appeal courts clearly stated boldly that Kanu cannot be tried in any other court in Nigeria after a judgment was being given. At this point, I'll let you guys tell me what you feel about this in the comment section below. Do well to like this video, share this video, and hit the subscribe button below for more trending updates.